Hi everyone, I'm Nicole Hemrick and I'm the founder and managing partner at Hemrick O'Malley PLLC. Today we're breaking down an important development in immigration law, the U.S. Chamber of Commerce's lawsuit challenging the recent presidential proclamation that restricts H-1B entries and imposes a shocking $100,000 fee on certain petitions. If you employ H-1B professionals or you're here in H-1B status, this could directly affect you. Let's take a closer look at what's happening and what it could mean for your future. As you know, on September 19th of 2025, the White House issued a presidential proclamation that does two major things. It restricts entry for certain H-1B non-immigrants after September 20th, 2025, and it imposes a new $100,000 fee per employee on employers who want to bring those workers in the United States. Employers could be exempt only if they receive a national interest exception or the employee is otherwise not subject to the fee. The problem? The rules are still very unclear. USCIS hasn't yet begun collecting the fee, and there are many unanswered questions about who exactly is covered and how the government plans to enforce this. Fast forward to October 16th of this year, the U.S. Chamber of Commerce filed a lawsuit in the federal court at Washington, D.C. titled Chamber of Commerce versus DHS. The Chamber of Commerce argues that the proclamation is unlawful because it exceeds the president's authority under immigration law. It misuses the limited power to suspend or restrict entry of foreign nationals, and it fails to justify why H-1B workers are supposedly detrimental to U.S. interests. They also allege violations of the Administrative Procedure Act, which requires that many policy changes go through proper notice and comment, something that did not happen here. This case follows another similar lawsuit, Global Nurse Force versus Trump, filed earlier this month in California, which also challenges the proclamation on similar grounds. So what happens now? We expect the plaintiffs in one or both lawsuits to request an injunction, meaning they'll ask the court to block the proclamation and stop the government from implementing the $100,000 fee, at least temporarily. Until the courts act, employers and foreign nationals should stay alert. If an injunction is issued or new government guidance is released, the rules could change overnight. At Hemrick O'Malley, we're monitoring these developments closely and will keep you updated as soon as new information becomes available. If you're an employer sponsoring H-1B workers or an H-1B employee wondering how this might affect you, now is the time to review your immigration strategy. You can contact us at 833-848-7838 or check us out online at www.hemrick.law. We're here and ready to help answer your questions. Stay informed and remember, as always, stay hopeful.